We're back with you tonight, here on In Focus. The Jacob Zuma Foundation says former President Jacob Zuma is going ahead with a private prosecution against lead prosecutor in the corruption trial, Billy Downer. Zuma has accused Advocate Downer of bias and leaking his medical records to the media. It wouldn't be the first time in South Africa that private prosecution has been used to seek legal recourse. Among the prominent cases is an alleged hit-and-run case against Zuma's son, Duduzane, who was acquitted of culpable homicide and reckless driving in 2019. Joining us now to discuss the pros and cons of private prosecution is legal expert Benedict Phiri, who is a practicing attorney. Good evening, and thank you very much for joining us tonight, Mr. Phiri. The mere decision that the NPA has given the certificate that they will not prosecute, does that in itself say there is very slim possibility of success in the prosecution?
Not necessarily. It just means that at least from the NPA and the DPP's perspective, they don't believe that there are prospects of success in this case. But we have seen, as you've indicated, other private prosecutions where the DPP has been reluctant to prosecute, but the private prosecutor has succeeded with the private prosecution. And then in this particular case in particular, the charge that the former president will be bringing against Advocate Billy Downer basically relates to a provision in the NPA Act which says that a prosecutor is not allowed to disclose any information that he obtains by virtue of doing, or rather undertaking, his duties unless he's being given authority to do so, or also unless it's in the course of conducting his duties. So the charge is quite simple that we expect to come is that, Advocate Billy Downer disclosed this information in circumstances where he wasn't authorized to do so and in contravention of the NPA Act. So obviously we don't know what the position will be insofar as the facts from Billy Downer's perspective, but certainly that's what the former president will be putting forward to Billy Downer in this instance.
So, this issue of the leaking of sensitive information, private information obtained in the course of the scope of his work, how serious a charge is that, and what are the legs on which you would need to stand on in order to prove that?
Well, it's a serious charge when you look at the NPA Act because it attracts very serious punishment. If I recall correctly, it's up to 15 years, which, is quite serious punishment. And when you look at the wording of the section which creates the criminal offense, it appears to create quite a strict liability in the sense that you either have authorization to disclose the information or not. And if you don't have the authorization and it's not being disclosed in the course of your duties as a prosecutor, then you should be liable of that crime. Obviously, we need to check whether Advocate Billy Downer did have authorization to disclose. First and secondly, whether he actually disclosed information that was not public. We know that Advocate Billy Downer says, well, the information was already public by the time that it became disclosed, so it wouldn't trigger that section. And then over and above that, what you'd also need to check was whether if it was disclosed in contrary to the section, whether this was in the course of his duty. So there's still a few legs and hoops for the former president to prove in that context. But if he should prove them, it is a serious charge which attracts quite a hefty prison sentence.
Yeah, the president then saying there is evidence that criminal conduct has taken place in an attempt to manipulate the investigation and prosecution for unlawful purposes. What would the court be looking for there, particularly the type of evidence that then he would need to present that indeed such criminal conduct has taken place?
And to be honest, the second part of that, the attempt to manipulate court processes is absolutely irrelevant. The real question would be, did Advocate Billy Downer disclose of information without authority in circumstances where he shouldn't have disclosed that information? That's really the question. what the motive was or what the reasoning was behind the disclosure is really sort of far from what the actual essential of the charge encapsulates. And ultimately, all that the former president would need to be able to prove to be successful, obviously beyond reasonable doubt, because we're looking at a criminal standard of proof here, would be that Advocate Billy Downer disclosed information when he shouldn't have disclosed that information and without the authority to do so. We know that Advocate Billy Downer's defense so far, at least his line, has been that this information was already in the public domain, so I could not have fallen foul of that provision of the NPA Act.
Yeah. In one of the reports I read here, a supplementary affidavit was given by Advocate Downer, and that document, he says, the note was given to a journalist by NPA advocate Andrew Breitenbach with an embargo which the journalist had respected. Would that have any bearing on the outcomes?
I think that would certainly be a factor that would be taken into consideration in considering Advocate Billy Downer's intention, because when we look at criminal law, we actually look at the intention relating to the act or the conduct that follows the intention. So if there is an embargo, it certainly goes to at least indicating that, within this context, there wasn't an intention to actually break the law. In the sense that, this information was still kept within secret confines, if we can call it that, and still meant to give effect to the spirit of that section of the NPA Act. So it's certainly something that will weigh in the assessment of, assessing whether there was actually an intention on the part of Billy Downer in this particular instance to contravene that section of the NPA Act.
Now, with the certificate having been issued, is there an investigation that would still need to ensue here?
Well, typically what then should happen in this particular instance is that the DPP should then afford the former president, access to the documentation, the witness statements, any affidavits that they have, that went into the decision not to charge Advocate Billy Downer, so that, the former president isn't starting again this investigation from scratch. So I anticipate that, he will be afforded the same information that the DPP has. We know that he says, the former president, that he's far gone in preparing this charge sheet, so I'm assuming that he's got all the relevant information to ensure that he can proceed as expeditiously as possible. He does have 3 months to proceed, and that particular provision in the fashioning of this section basically got extended from 6 weeks to 3 months to afford private prosecution litigants the ability to gather the evidence and put themselves in a position where they can actually conduct the prosecution sufficiently. Right. So I'm anticipating that by the time that it is actually launched, the former president would be in a position where he would have completed his investigations that would satisfy him that he'd be able to conduct this prosecution successfully.
That is Benedict Phiri there, practicing attorney, legal expert for tonight, bringing us that intervention on what it means to prosecute in your private capacity.